So good morning, everyone, and welcome to the Hospitality Newfoundland and Labrador webinar this morning, the impact of legal cannabis on your business. My name is Juanita Ford, and I'm with Hospitality Newfoundland and Labrador. We are very pleased that you could all join us today, and we're looking forward to some great discussion. So just a little bit of background information. Hospitality Newfoundland and Labrador is the tourism industry association for the province and has three key mandates, which include advocacy, membership development, and learning. This year we are celebrating our 35th anniversary of guiding the growth of the industry and our members. Thank you all for joining us today. Our role is to provide our members with information they need to run their businesses. As we can see from the large number of people that have signed on to the webinar this morning, that through this webinar platform we're able to get the needed information to all regions of the province at one time. So the reason for our webinar today is that on October 17, 2018, the Government of Canada will legalize recreational consumption of some cannabis products. The impacts of this change will be far-reaching, affecting areas such as workplace safety, employer-employee relations, human rights accommodation, sober driving, and regulations of cannabis production, sale, and consumption. Today, we will review the impact of cannabis on your business as regards to operating your business and dealing with visitors who may be consuming the product. We are happy today to have Blair Patrick here with us. Blair Pritchett. Sorry, Blair. Blair is the partner and board member with the law firm of McGinnis Cooper. His legal practice focuses on representing employers on a wide variety of labor relations and human resource matters. Blair has spoken extensively on the topic of cannabis legalization, in particular cannabis in the workplace, delivering seminars and professional management and client groups. He has also been featured on local media outlets discussing the pending legalization of cannabis. So without further ado, I'll pass it over to Blair to get started.
Hey, thanks for the introduction, Juanita. Hello to everybody out there listening. Really great to see so much interest in the presentation. I appreciate everybody taking their time to join us today. As Juanita would have said, I'm happy to take questions throughout. I think the easiest way to do that is probably through the chat function. That way I can sort of respond when it's appropriate and minimize the interruption for everybody else. But by all means, if you have a question, let me know. And if I haven't been clear on something, I'm certainly happy to address that. I guess to get started, I mean, next week, which sounds very soon, we've been talking about this for a long time, but next week, on October 17th, there's going to be some fundamental legal changes in terms of what's permitted. That's obviously something that everybody knows. What I think is probably not as widely understood is that this is not going to be something like the legalization of alcohol, where you can have as much alcohol on your person or in your vehicle as you wish. You're pretty much unlimited in terms of your ability to consume. Cannabis is not going to be like that, and there's going to be a public limit on the amount of cannabis products you can possess. So if you're out in public, you won't be able to have any more than 30 grams on your person. A little later in the presentation, we'll have something pop up in a window on your screen which will show you roughly what that looks like. But basically it's half of a sandwich baggie, roughly the size of a $10 bill is 30 grams or roughly 1 ounce. In terms of what will be allowed carrying on, the growth of cannabis for personal use is a pretty significant change, and that's something you're limited to 4 personal plants that you can grow for your own use, but obviously that's a very big change and something that was a criminal offense. It remains to be a criminal offense today and will be until next week. On your screen now, you should see a picture of, I assure you it's not real cannabis, but it's the closest thing I could find at the bulk barn. But you can see it's not a huge package in terms of volume or size, and that's roughly the possession limit you'll be looking at next week. The other things of what will be allowed is people who are operating licensed businesses will be able to produce, distribute, and sell cannabis publicly. And in terms of your own personal possession, home, in private property, there's really no prescribed limit at all. So I guess moving forward, that raises the question of what won't be allowed, and there will be a range of things that will actually still be criminal offenses even after the legalization is complete. So in terms of what will remain criminal offenses, a few things to be aware of. Any public possession of an amount more than 30 grams will be a criminal offense. Growing more than 4 plants at home would be a criminal offense. And also it will be illegal to, I guess, buy marijuana the traditional way, which is through an unlicensed underground dealer. You know, that will remain as illegal tomorrow as it is today. And for the most part, it's not something that you'll be able to publicly consume. There will be exceptions in place for people who have a medical authorization, but for the most part, at least in this province, consuming a cannabis product in public is not going to be permitted. So obviously when we're talking about things that will remain criminal offenses, there are going to be penalties in place, and they are actually quite severe for some offenses. So, for example, unlicensed sale or trafficking of cannabis, starting on October 17th, is still a major criminal offense. The maximum penalty for that is up to 14 years in prison. So it remains a very significant offense to be charged with, and something people should be aware of. The public possession limit is actually 30 grams, but there is a small window where if you're slightly over that, you would have a relatively minor offense and maybe get a small fine. But if you're over by a large amount and you're possessing more than 50 grams, you can actually be subject to a significant term of imprisonment. The same thing would apply to plants. If you're growing 5 or 6 plants, you're going to be charged with a minor offense, issued a ticket, and pay a fine. Beyond that, it would be treated much like a grow operation would be treated today, and you could be charged with a crime that could lead you to serve time in prison. One thing that's probably not a lot of people, something that not a lot of people are aware of, is the notion of procuring cannabis for a minor. And I know most of us probably don't have to dig too far back into our past to remember a time when people might be in high school and someone who recently graduated high school might buy a 6-pack of beer or something for their younger friends. That's actually going to be a very serious offense under the cannabis legislation. It could actually land you a prison term of up to 2 years. So for people maybe in a certain age group who may not think of this as a serious issue, it's definitely something to be aware of. And I know when I think back in my own time in high school, this kind of thing was probably pretty common, and I think it would be something that most people should be aware of, and probably most parents of teenage children would want to share with their family members. There was a question posted online about the household, about growing plants in a household. My understanding is that it would be limited to the household, that there couldn't be more than 4 plants in the one household. One of the questions, of course, raised by these things is you're always going to get complicated arrangements, right? I mean, you may get people in university who are renting a room, and there's 3 of them in an apartment, and they're each growing their own marijuana, maybe secretly. So there's a lot of stuff that's going to be open to interpretation in the courts. But my interpretation right now would be that it would be a household limit, and it would be pretty risky to go beyond that, even if there is more than one adult in a home who's entitled to grow. As I mentioned, there are some relatively minor offenses that will be created. So a possession in public of an amount that's a little bit more than 30 grams would be a ticket and a fine. The same with growing 5 or 6 plants. Consuming in public will be a relatively minor fine, probably roughly equivalent to drinking in public. So something that police will probably be aware of, but maybe not strictly enforced, and certainly not something that would be life-altering in terms of a charge. And there are also some rules, or quite a few rules, about operating in motor vehicles, and I'll get to that a little later. One thing that will remain is medical use, and medical use maybe won't be as valuable to people going forward as it is today, because today it's a crime to possess marijuana or smoke marijuana unless you're using it for medical purposes and you're authorized to do so. There'd be limited value in that in a few months, because by and large everybody will be able to do that, at least everybody who's over the age of 19. What's interesting is that this has been around for quite some time. It's 17 years ago now that the Supreme Court of Canada said it's unconstitutional to prohibit people from using cannabis for medical reasons. So in as much as cannabis is pretty common in our culture and people use it recreationally and have for a long time, it's also been medically used for a very long time. The program for medicinal use is administered by Health Canada, and you do need a medical authorization from a qualified physician to access it. The interesting question, and in fact the Canadian Medical Association has weighed in on this, the question is, how relevant is this program going to be in a world where marijuana is readily available and people can consume it on their own time? You might think of it as you might think of something like aspirin, where if you need it, you can just go get it and you don't need any kind of special permission. And the Canadian Medical Association has formally suggested that maybe the medical system should be scrapped. That's something to watch for sort of moving forward. Someone asked about public possession and how that is defined. That's actually a good question and probably something I should have built into my slide. I mean, any sort of public place, like on a public street, in a business that's normally accessible to the public, in any kind of motor vehicle, on a boat, on a bus, in a car, all of those kinds of situations are public. So really, unless you're very much on private property that's not ordinarily open to the public, then you would be considered to be in public. The medicinal use, a couple points about that. I mean, it isn't quite like a regular drug. You don't go to your family physician typically and get a prescription where they say, as odd as this may sound to some people, smoke 2 joints a day, do not mix with food or what have you. What you get is an authorization to use it for a diagnosed medical condition that allows you to register with Health Canada and access the medical program. The thing that actually quite shocked me about this program is how widespread it is. Health Canada reports that they have, it's something like 297,000 active client registrations. And if you look at the demographics from Statistics Canada, there's about 30 million Canadians who are over the age of 14. So if we assume that children are not being prescribed or authorized to use marijuana, that means about 1 in every 100 people who's over the age of 14 is actively consuming medical marijuana today. So that's a pretty significant percentage of the population, and speaks to, I think, how common the consumption of marijuana is, whether or not people are seeing it in their everyday lives. My friend Peter from Battle Harbor has asked a question about is the consumption of medicinal marijuana different from recreational use? Can they smoke it in public, for example? And actually, Peter's sort of happened on really one of the critical differences between the two. And it does appear that you will be able to consume medicinal marijuana in public, which is something that recreational users won't be able to avail of. That raises the question, of course, how is a police officer to tell by looking at you if you're standing in the middle of Bowring Park with a joint? How are they going to know whether you have an authorization or not? But that is what's going to be rolled out next week, is medicinal use in certain public situations is valid. I'll explain a little later in the presentation about, I guess, the relationship between smoking cannabis and smoking cigarettes, because there are going to be similar limitations there. But Peter's question is a good one. In terms of what to do with your business and how to approach this, I always say, I'm not sure if this is clever or not, but I call it the rule of cigarette, Percocet, and keg, which is probably the world's most exciting law firm, I suppose. But when you think about cannabis, it's a different product in terms of how it can be used. It's most commonly smoked, although it doesn't have to be. So in that respect, it's very similar to a cigarette. It's also used as a medication, so it would be equivalent to Percocet or some other kind of painkiller, which is a common use for medicinal marijuana. And it's also similar in some respects to alcohol in that it will be a recreational, a drug that's consumed recreationally and has intoxicating effects. So depending on how it's being used or what the context is that you're seeing with your business, I think you need to ask the question, for example, would it be acceptable to smoke a cigarette in this situation? So someone has asked online, can medical marijuana be smoked in a hotel guest room? The basic rules of where you can smoke marijuana are going to be the same as where you can smoke cigarettes. So anywhere where you are legally restricted from smoking a cigarette, you're going to be legally restricted from smoking marijuana. The rules, as I'm sure many people on the call will know, is that when it comes to something like a hotel room, the only permitted opportunity to smoke in a hotel room is something that's basically designated and wouldn't be subsequently designated as non-smoking. So in other words, if I stay there and I don't consume, it can't be non-smoking, and then the next guest smokes and then the next one doesn't. It has to be something that's designated. So that's a good question. Medicinal marijuana is a little different in that you might expect to get some blowback. I mean, my recommendation and my approach would be that if a place is non-smoking, the reason for you consuming it is really irrelevant. It's very likely that someone's going to challenge this under human rights legislation, and it remains to be seen how it would be dealt with. But I think the way the law is written is that smoking marijuana or cannabis products is exactly like smoking a cigarette for the purposes of the tobacco. I'm struggling to recall the name, but the act that limits smoking in Newfoundland and Labrador. If you're thinking about it in a medication, I think as an employer or business owner, I'd ask myself, would it be acceptable to be under the influence of a narcotic pain medication in this situation? So, if you're sorting books at a library and you're taking a pain medication that's maybe mildly affecting your mood or your state of mind, maybe that's not a big deal. If you're operating a crane or if you're working on ski patrol at Marble Mountain or something like that, obviously it's a very different situation, and it all depends on the context. But I think the question is, would it be acceptable to be under the influence of a pain medication? That's an excellent way to think about this. And the last one, which from at least an employment perspective, I think the answer is pretty obvious, is would it be acceptable to be drinking alcohol or to be under the influence of alcohol in this situation? And generally speaking, in a workplace scenario, the answer to that is almost always going to be no. Someone has online has asked a question about smoking in a hotel room, and one of the obvious differences between marijuana smoke and cigarette smoke, I guess we're between friends here, so we can admit we know this, is that it's a pretty significant difference in odor. And it raises the question, and I think it's a fair question of, are you going to want this in your business? I think it's an interesting question that I hadn't really thought of before, but the reality is, under the law, cigarettes and marijuana cigarettes are going to be treated the same when it comes to where they can be consumed and where they can't be consumed. So but just to finish that point, I think you need to be cognizant if you're going to have a designated smoking area, like a hotel room. You may be you are almost certainly opening yourself up to the possibility that someone will use that place to smoke marijuana. Now, I guess the question would be being raised is about having marijuana in your hotel room and not being smoked, and whether or not it would create an odor that would maybe permeate to other rooms. I mean, that's a bit of a challenging question. I think you'd almost have to treat it like others. You know, how would you deal with it if somebody had, as bizarre as this may sound, salt fish in their hotel room, or garbage, or had spilled alcohol or something? You know, I think you almost had to think of it in those terms. If it's a nuisance to other guests, I think you're entirely within your rights to say this is something that needs to be stored in a way that's not intrusive on other people. If it was something like a food odor or a garbage odor that you wouldn't address, then maybe it's going to be a bit more challenging. Yeah. So here, this is the name that had eluded me earlier, the Smokefree Environment Act, and that's what prohibits smoking in a wide variety of places today. And the government has imposed a very simple fix on this. They've amended that legislation to add smoking of cannabis products to the definition, so it's exactly the same as cigarettes. So any public place would be a limitation on additional limitation on marijuana. But anywhere smoking is prohibited today, marijuana smoking is going to be prohibited tomorrow. Any vehicle, any boat, any car, any bus, any form of workplace like a bar or a restaurant, any office building, any commercial establishment open to the public, any common area of a hotel, recreational facility, daycare, you know, the list is healthcare facilities. It goes on and on. So basic rule of thumb, if you can't smoke a cigarette there today, you can't smoke a joint there tomorrow. But I do think business owners need to think long and hard about how smart it is to have a designated smoking area in this new era, because you are probably going to have to live with people smoking cannabis if you allow that, and that's something that you may not want, depending on what kind of business you're operating. In terms of what to do with your business, as I pointed out, there's 1 in 100 adult Canadians has an authorization to use marijuana for medicinal purposes. I think the number in Newfoundland is probably a little bit lower than that. But there are more than 3,000 people in Newfoundland who have medical authorization. So it's a virtual certainty that there are people on this call right now who have people who work for them who have medical authorizations. Whether or not you as the employer know it or not, it's most definitely happening. But I think this is kind of where we back up to sort of the narcotic pain medication and how would you deal with this. I mean, first of all, employees are not entitled to be high at work. Right? I mean, you need to present to work in a condition appropriate to do your job, and whether you're, as we might say, stoned after smoking a joint for whatever purpose, whether you drank heavily and are intoxicated for that reason. I mean, there are a lot of different reasons why you're not in an appropriate state of mind to work and able to carry out your duties appropriately and safely. And it's really not on for an employee to show up in any of those conditions. And I don't think there should be any expectation for you as employers to be tolerant to that. Now, if you have an employee who is using marijuana and this comes to your attention, if it's for treatment of some kind of medical disorder or disability, it is something you need to consider under human rights legislation. But I also would suggest to you it's not something you need to just blindly accept. You are entitled to ask questions, to maybe draft a letter that could be sent to the personal physician who's authorizing this to get some details about how often is it used, how potent is the cannabis that they're using, maybe most importantly, what are the alternative therapies, right? I mean, there are very few things that cannabis is used for that it is the only possible option. It may be for some people that for certain disorders, it's the only thing they can do. They've tried everything else, and it's been ruled out. But very commonly, that's not the case. And when you think about it, I don't know how many people on the call are in the St. John's area, but if you drive up Torbay Road, you'll see a big sign on the side of the road that tells you, why wait till October 17th? Get legal now. So there are businesses out there who are catering to people to help facilitate them getting medical authorization for convenience. So, which is not to say you need to look at your employees, with great suspicion, but I think it's worth exploring and having the conversation. Is this really necessary? Because in many cases, it's not. I mean, marijuana is something that people like to smoke and consume, and they like the impact, and therefore it's often a drug of choice for certain conditions because it sort of suits somebody's predispositions and their lifestyle. But that's not always going to be the case, and I think you're entitled to push back on that, get some more detail, and at least satisfy yourself that it's necessary. And once it is necessary, assuming it is, the other questions are, what is the residual intoxication effect here, and what is the impact on the employee's specific job duties? Because I've seen lots of cases where doctors have authorized people to use medical marijuana, but they really haven't given any consideration to what the person does for a living. And I would suggest if you're in a highly safety-sensitive job, if you're operating heavy equipment or something like that, it's a rare doctor that's going to say this would have no impact on their duty. So if it is necessary, and you should explore that, you also want to know what's the potential for residual intoxication and what impact might there be on the person's job duties.
There are several questions there. Did you want to take a minute to address those or wait till the end?
No, I think there's probably a couple there that are best addressed right now.
Okay.
There is a question about saying, are you allowed to require direct medical information about medical usage? I guess there are definitely lines that you can't cross as an employer. You're not really entitled to know what's wrong with your employee. We always say you can't ask for the diagnosis, you ask for the prognosis, right? So you're not entitled to know that a person has arthritis or breast cancer or schizophrenia or whatever the disorder is that they suffer. What you are entitled to know is what limitations they have in terms of how that impacts their workplace, whether it's maybe they can only stand for certain periods of time, maybe they require frequent breaks, maybe they can't work night shift because of a sleep disorder. But there are lots of things. You are entitled to be told what their limitations are in performing their job duties. You're also entitled to be told the details of the use of a drug that could potentially impact that. So why the person is using cannabis will probably be a mystery. You can still ask the question of whether or not it's the only available therapy, but you are 100% allowed to ask what's the frequency of use, what's the dose, how close to work hours is the person consuming it, what's the likely intoxicating effects of that. You can ask all those questions, but it's a good point to say you can't explore either directly with your employee or with their physician. What's wrong with you? That's not a fair question. The question is, what are your limitations in doing your job, and what kind of medical treatment are you taking that might impact your job? And in terms of, there are a couple of questions about smoking cannabis on a recreational basis. And again, I think I'd simply go back to my comments earlier about it is exactly the same as cigarettes in many places. But in addition, if it's a true public place, and if it's a place where the public is generally permitted and expected to be, then public consumption is not allowed in Newfoundland. It's not going to be like that everywhere in Canada, but it will be at least initially in Newfoundland. So if you have a a trail network around a recreational facility, it is exactly the same as bringing a six-pack of beer and sitting down on the side of the trail and drinking your beer. Now, realistically, how aggressive will police be in chasing that down, and how likely is someone to be charged? They may write tickets initially, they may not, but it's unlikely it's going to be a significant priority unless unless it's becoming a real nuisance. There are some questions about that I think relate to this slide about human rights accommodation. Your obligation as an employer is that if you have an employee who's suffering from a disability or a disease, you do have the obligation to accommodate that disability or disease. And accommodation would also extend to what are necessary treatments of that. So if you have an employee who's, let's say they're dealing with chronic pain and medication is required to manage that, you do have to accommodate that, but only up to the point of undue hardship. So somebody's raised the question here about a safety-sensitive job. So for instance, if you're working in a warehouse operating a forklift, my suggestion would be that as an employer, it's not appropriate to have somebody employed in that job who's under any level of impairment or intoxication. So what you need to do is sort out, first of all, is this the required treatment? What are the likely residual implications in terms of being intoxicated? For instance, if somebody's smoking marijuana to manage pain at night, what kind of state are they in at 8 o'clock the next morning when they report for work? But if you have an employee in a safety-sensitive position and their consumption regime requires them to have levels in their system that their physician is saying will be intoxicating, my approach would be that they can't work in a safety-sensitive job anymore. And if that's the only job, that's the only kind of role you have, then they will be in a difficult position. I guess the other thing about accommodation is it applies to issues of treatment and it applies to issues of addiction. And addiction is probably the most problematic one for employers because you often find out about that the hard way. There are a lot of people who are marijuana advocates who will say that addiction is not a meaningful issue. The reality is that it is a diagnosable condition. The medical profession across Canada, North America, and the world recognize it as a medical condition that can be diagnosed. It's probably not nearly as common as other forms of addiction. I don't think it's viewed to be nearly as addictive as narcotic pain medication or even alcohol for that matter, but it is possible to have someone with a legitimate medical diagnosis of addiction to cannabis, and it is something you have to address. You don't have any obligation to accommodate recreational use. I mean, anything that's a voluntary lifestyle choice that interferes with your ability to do your job, your employees do it at their risk. There is a question on there, but how do you know if somebody's using cannabis? I guess a couple of things. First, on accommodation, you need to accommodate someone who you know to be, who's requested or requires it. So if somebody comes forward and presents as having to use this medication, then you can have that discussion. But if you're just dealing with someone who's not raised anything and appears to be intoxicated, high, drunk, however you want to characterize it at work, then until you have information to the contrary, I would simply treat it as a disciplinary concern. In terms of how you would test for cannabis, I have a little bit of that on the end of the presentation, but that is a very open question. Right now, police are being trained to observe it, to observe behavior and make an assessment as to whether or not somebody's intoxicated. That is probably not 100% reliable, and there's a lot of different reasons why somebody could appear like they might be intoxicated. That's going to be difficult to impose for employers. There is a breath detection device that's going to be used by police. Its reliability is very much in question, and the preliminary data is apparently that in cold weather climates it doesn't work great. So we're rolling that out on October 17th in Newfoundland. We'll see how that works. The most reliable test is probably a blood test, but that's very invasive and difficult to administer. That's what's going to be used under the criminal code to convict people. But even then, and I guess I might as well address it now, even then, we don't, you or I or the world's leading scientist does not know how intoxicated someone is based on their blood levels for THC, which is the compound in marijuana that gives the intoxicating feeling. There are limits under the criminal code, and if you have this in your blood and you're driving, you'll be charged and potentially convicted, severely punished in some cases. But it is a fundamental challenge that nobody really knows what it means to have these blood levels reported. And every person on this call could probably have the same consumption pattern and the same blood level potentially, and have a completely different impact. So that is a very big challenge for employers, and really remains to be seen how it can best be dealt with. The only note of comfort I can offer, and maybe this is not very comforting, is that we know that 1% of people in the country are using it already for medical reasons. I would suggest that the data suggests that depending on your age demographic, the numbers of recreational users might be more like 20 or 30%. So you're already dealing with it, whether or not you know it or not. But it is a very difficult scientific question that is not yet answered. How are you going to test for this, and what does it mean? I mean, my own inclination is I'd follow. The criminal courts are going to drive the bus on this. They have already enacted standards. People will be charged. It'll be tested. People will raise constitutional challenges, and we'll see how that flies. And let them do the hard work. But that's where the best information is going to come about legally enforceable testing, what reasonable limits are, and what the consequences might be. Sorry, there's a question here that maybe popped up earlier and I might have missed. Question about a hotel guest being permitted to smoke cannabis in their vehicle for medicinal or recreational use. There's no circumstances where it will be legal to smoke it in a vehicle or to have. It is exactly like alcohol in that respect. You can't drink it in a vehicle, and you can't have an open package in your vehicle. Cannabis would be sold in sealed containers, which will have. I guess I haven't seen what a legal one will look like, but it will have a seal on it, which must be broken when you open it. And having something in your vehicle with the seal broken will be a driving offense. Consuming it will be a driving offense, and I would think of it exactly like alcohol. So if you have someone on your business property who's engaging in that, I would maybe question of discretion how you want to handle it, but I would do exactly what you would do if it was a bottle of beer. Another question is, can you have a zero tolerance policy towards THC detected? My gut reaction is no. I think people are going to, well, I know people are going to try it. Before we got on the call, we discussed some recent news. I think the city of Calgary is saying to their police officers that off-duty or on vacation or not, you can't consume cannabis products, period, ever. And a positive test will lead to discipline. I don't think that's going to fly. The best evidence that's out there, we don't have evidence about what blood levels mean of THC. We do have evidence that a 24-hour window after consumption is typically sufficient to allow someone to be completely clear of the intoxicating effects. So I would tend to think of it in terms of having policies that create windows of use. So in other words, you shouldn't consume a product within a certain time of reporting to a safety-sensitive job. These things will be tested a lot because, again, the bleeding edge of this is going to be in, firefighting, policing, airlines. People are going to have very aggressive policies, and they're going to be challenged. And that'll tell us a lot. But I think zero tolerance would be a problem because as I understand it, if I take 4 weeks of vacation and go to Mexico, and on the very first day of my vacation I smoke a joint, the day I come back and start work 28 days later, I may test positive in my system. So it's a very long-lasting drug to have traces in your system, but it does not appear to be a drug to have long-standing residual intoxicating effects. And that's the risk with zero tolerance. Whereas if you compare it to something like cocaine, I don't have the data in front of me, but is something that clears your system very quickly. I'm told some people like it as a drug of choice for that reason. And so a drug test of cocaine is a much more reliable way of assessing recent use and possible intoxication. Someone asked about asking upon employment application if medical marijuana is prescribed and whether you can ask. I would be inclined, I wouldn't ask that question for a number of reasons. One is you're kind of inviting someone to go down the road of human rights discussion. And I would take the view that if you have someone who reports for work who's obviously intoxicated, who's smoking marijuana, who smells like marijuana, or you see them smoking on a break, I'd treat it as a disciplinary issue and wait for them to say that there's some appropriate justification. It's always dangerous to ask medical information on employee intake. I mean, it would be akin to asking, maybe not quite as dangerous, but akin to asking a young female applicant if she's pregnant or plans to become pregnant. You're really setting yourself up for a fight that may not be at all necessary. I don't think I need to spend a lot of time on the next slide here. I mean, in terms of recreational use, I would treat it exactly like alcohol. You have no entitlement to drink at work, to be drunk at work, unless maybe you're a wine taster or something. I guess there might be people on the call who have legitimate use of alcohol in their workplaces. But generally speaking, it's entirely appropriate to say, you can't report for work in an intoxicated condition, nor can you consume this intoxicating drug while you're at work. I'd be inclined to be that cut and dry about it. I think I'm almost at the end of what I'd intended to go through. I see that Angela in Deer Lake has raised her hand, so maybe Angela, in a minute or two, you can ask a question if that's okay. Just a couple words about drug and alcohol policies. I think it's a very important thing for a business in this day and age to have if you have any number of employees. If you do have one, and again, I strongly suggest you should, your employees should know what it says. So, it's the kind of thing you want it posted in a convenient place, in a staff room or something like that. You want to provide it to people on hiring. I'd be inclined to get people to sign off on it on hiring, and I'd also give reminders from time to time, just so that you're never in a position where somebody says, I didn't know I wasn't allowed to smoke joints during my morning coffee break in front of our place of business. It's the kind of thing that, that's maybe an absurd example, but you want to be in a position where you can say, listen, this is completely, this is what the rules are, and you accept these, and if you're going to work here, that's the way it's going to be. One thing that you should look at if you have a policy, and kudos to you if you already do, is you probably want to look at the wording, because a very common language that was being used was alcohol, prescription, or illegal drugs. Marijuana is none of those things necessarily. Right? Recreational use of marijuana was not contemplated when most people wrote policies. So you may have one today that is otherwise effective, but doesn't address consumption of marijuana recreationally. I know I'm heavily involved in the sport of swimming in Newfoundland, and we just had to amend our policies for swim meets to incorporate that, because there's language about kids not drinking or smoking and be punished for engaging in that kind of activity. But cannabis is something that would have fallen through the cracks. So everybody should have a quick look to see if your existing language speaks to that. The other thing that's interesting is that driving is going to be an interesting question. The province has brought in legislation that has a strict prohibition for certain people. Like, there's absolutely zero tolerance for people who are novice drivers, who are under the age of 22, or are what's classified as commercial drivers. I know somebody's going to say, what does it mean to be a commercial driver? And that's not really fully defined or tested, but I would say anyone who's driving a motor vehicle that's, carrying goods, carrying passengers, in any way directly related to the delivery of your service at work is probably a commercial driver. And it raises some serious questions for employers who have vehicles. Because one of the, I just have this is really bad for radio, but I have an interesting piece of paper here that I can see and you can't. But commercial drivers who test positive for the presence of cannabis in their system on a roadside screening will have a 7-day license suspension and a 7-day vehicle impound. So that's not going to be a very good situation if you're driving a corporate vehicle. And it also raises the question of how you're going to deal with the employee who's hired to drive and has a suspended license. And it may well be that there will be a rash of people who are either disciplined, suspended from their jobs, or maybe even lose their jobs because they lose their capacity to drive in the short or the long term. And some of the more escalating suspensions may be a 90-day suspension if someone is deemed impaired by cannabis while they're driving. And in the tourism industry, for example, a 90-day suspension can be crippling if it happens on the 1st of June. So it's something you need to be aware of, and it's going to be very interesting how this plays out, because a person who's 19 is fully entitled to consume cannabis on October 18th. But the government is saying, while you're allowed to consume it, you can never drive a car when you have a trace of it in your system. And that's going to be interesting to see how that plays out. I have a question here about a facility that holds events and serves alcohol. Obviously, a lot of people would be in that category. I mentioned this in the context of hotel rooms, but I think in general, if you are going to have a designated smoking area, unless you take some active steps to try and prohibit the use of cannabis, it may well be, if it's a non-public area, it may well be that people will be smoking cannabis there. If you have a designated smoking area, say outside your establishment on the parking lot in a relatively public place, that's a situation where in Newfoundland you could smoke a cigarette but not a joint. But I think you need to think long and hard about having smoking areas in your business and consider whether or not someone could legally smoke cannabis there if you allow it, and then think about whether or not you think that's a good idea for your business at all. The question, someone asked the question, does zero tolerance for young drivers extend to medicinal pot? I think that's an excellent question. That is exactly where the first court challenge is going to come from. Somebody who's in that 1% of people with a medical authorization is going to get pulled over. They're going to have a completely minor level of THC in their system. They're going to lose their license, and then they're going to either institute a constitutional challenge or a human rights case, and someone's going to source that out. My strong inclination is that someone who is not intoxicated, who has a trace element in their bloodstream, it's going to be very difficult to enforce that person is not. I don't know how the province intends to deal with this, but I think they're going to have a real issue in enforceable in the longer term, because people are going to. You're always going to get the most sympathetic case, right? It's going to be a young person who's suffering from a horrific form of cancer, who's managing pain and nausea with very low doses, and they have a minor level, and they're on their way to the hospital looking for treatment, and they get pulled over. And, how realistic is it that that person's ever going to be convicted, or that the penalty of having their license suspended is going to be upheld? So I'd stay tuned. It will be tested, but I'm pretty dubious about zero tolerance policies lasting. Drug and alcohol policy implications, a few quick points on that. I mean, I would address basic questions. Some people think you may not be able to restrict possession at work. I'm not sure I agree with that. I mean, you know, the workplace is owned effectively by the employer. I don't think there's any reasonable basis to have, I don't walk around my office with a flask of Screech in my pocket, and I don't think I should be able to walk around with 30 grams of weed, although I do, for presentation purposes, walk around with 30 grams of fake weed. You know, using it at work, I would say, is an absolute no-no. Being intoxicated at work, either freshly or on a residual basis. Again, same as alcohol. If someone, you know, made it home from George Street at 4 o'clock in the morning and then tries to show up for work at 8 reeking of alcohol, you know, that's not acceptable. It wouldn't be any more acceptable if they were consuming cannabis. And definitely, if you're in a safety-sensitive workplace, you need more rigorous policies. But you need to differentiate between people. So I've used the example of you know, say Marble Mountain, where you would have ski patrol and you would have people operating heavy equipment. They have clearly safety-sensitive positions, but the person who works the cash at the lodge is obviously in a different role, and it would be a mistake to try and apply blanket policies to a broad category of employees where some are safety-sensitive and others are not. And just, I think I covered this earlier, but, you know, I'll conclude by saying the problem of intoxication is a serious one, right? How is this going to be measured? I think the device being used is called a Traeger device. That's the initial road testing screening device. It's only been used, it's only been tested. It's not been proven to be particularly effective. I understand it's been used in Scandinavian countries and found to be unreliable in cold weather, so not exactly tailor-made for Canada and in a fall legalization. Blood testing is going to be around, but it doesn't necessarily tell us a lot. One thing that is interesting that I didn't know about till very recently is that the criminal code is amended, and it has limits for cannabis. It has limits for alcohol, which I'm sure everybody would be aware of, but it now has a combined limit. So I refer to this as the sort of slightly toasted exception. So you're a little bit high and a little bit drunk, but you're not legally high or legally drunk, but the combination of blood alcohol, I think it's 0.05, and a diminished level of cannabis added together will create a criminal offense and be charged and potentially imprisoned for having small amounts of both. And not to be too hard on our friends in government, but you know, they're often criticized for not being very proactive. But I thought this was a pretty clever one, actually, because it would be one way to circumvent the rules against driving while intoxicated, to have a little bit of two substances, but not a high level of either. But it's been thought of, and it will be a criminal offense. Someone asked about if a business could be fined if a person is found using marijuana in public. I'd be inclined to say no, with one exception. I mean, again, I would treat it like alcohol. Like if I'm operating a candy store and someone is drinking out of a liquor bottle in front of my business, I don't think there's very much. I might be able to go and yell at them, but there's not a lot I can do. But if you're in any way involved in the sale of marijuana, then you've got a different problem. So, you know, again, I'd think of it like alcohol. If you're selling beer, someone drinking in front of your establishment is bad. If you're not selling alcohol, someone drinking in front of your establishment is bad, but hard to see how you could be blamed. And again, someone asked another question about the smoking in public. I think, generally speaking, if you have a public area for smoking, but it's in a place where the general public can come and go, that's not going to be an acceptable place to smoke cannabis in Newfoundland. But you need, I think, if you're thinking about any kind of smoking area in any way connected with your business, I would sit down and look at the options and consider, is this somewhere where if we allow cigarette smoking, we might allow or encourage cannabis smoking? And then think about, is that a good idea for you to go down that road? Because I think most businesses would probably as much as cannabis is kind of something that people know about and tolerate and accept, I think most businesses don't want to portray the image that it's rampant at their place of business. And just final comments here on intoxication. There's a real gap in the science. If anyone on this call has a background in toxicology and can think of a great way to test for this, I would suggest you dive into that business today because it's going to be pretty lucrative. It's definitely a developing area of study, and there will be a lot of science that comes out now that things are legal because it's going to be much, much easier to investigate these. There's a lot of possibility for legal challenges under criminal law, under human rights law. So the rollout of some of these changes is going to be interesting, to say the least. And I think that's everything I'd wanted to cover. I don't know, do we have any questions that I haven't addressed?
There are a couple of questions. I can scan through and pick out those that might have missed, or if anybody wants to start to add some. So I think Mark has a question there. The last one just popped up. For multiple businesses operating out of commercial lease property, and one business designates the parking lot for smoking area, and the remainder of the businesses do not permit smoking in the parking lot, are there individual policies open to challenges?
That's a good question, and it's exactly the way legal problems arise, right? It's you start to apply the real world over some of these simple rules, and it gets messy. I think the answer to that specific question, though, is that a multi-use parking lot is a public place, and the public is invited to park their car there and walk to your business. So it would be something that in Newfoundland, at least, would be illegal, or Newfoundland and Labrador, sorry, would be illegal. Whether it would be illegal in Ontario is an open question. They're talking about more lax rules for public consumption. So maybe one of those really weird scenarios in Canada, which are not super common, we're doing one thing in Newfoundland and Labrador and doing it, let's say if you're in Lab West and you cross the border, the same rules may not apply on the other side. So in Newfoundland and Labrador, I think you're fine because it's a public place and you can't consume, but elsewhere, hard to say.
Okay. A couple questions there, basically, from a couple of people, Judy and Marjorie, wondering if they can demand tests of their employees to see if they're intoxicated or utilizing cannabis.
Generally speaking, well, not generally speaking, I would say in Canada, you cannot randomly test your employees for drugs or alcohol. It's not a legal practice. A lot of people have tried. It's been to the Supreme Court several times. There is a case still working through, but right now it's not legal to do that. You can, if you have a policy that allows for this, test in certain situations, and typically those would be where someone is, you have to have reasonable grounds to conduct a test. So you have a policy that says if someone appears to be intoxicated or someone's involved in a workplace accident and there's reason to think that drugs or alcohol may have been a factor, you can have a policy in place that requires them to be tested. If they refuse to be tested on reasonable grounds, they could be disciplined and could potentially be terminated. So you can't test randomly. If you have a policy that allows for certain limited testing with reasonable cause, you can do that. But again, the question remains with cannabis, what are you going to do when you get the answer that says they have this much THC in their system and you don't know what that means?
Okay. What about private outdoor spaces if they own a campground?
I knew people would be really creative. I mean, it's a place of business that you own. I think, generally speaking, your customers on your property are in a public space unless it's something like a hotel room where you have a reasonable entitlement to property, or to privacy, sorry. So it's, that's an interesting question. My thought would be it might make a difference whether you're inside the tent or not. But that's an interesting question. But ultimately, the question is it a publicly accessible place? Could other people reasonably be there? And does the person have an expectation of privacy? The other thing, of course, you could say if you have a campground is that it's a fire hazard and smoking is prohibited in all forms. and see how that goes. That might be a safer way to approach it. Someone asked about the smell of pot. I think I would be inclined to treat it like alcohol. I mean, maybe there's a good explanation for why somebody smells like weed when they show up for work at 8 o'clock in the morning. Most likely there isn't, but I think it would be the same thing. I mean, maybe someone who showed up smelling like beer could convince you that they were making a delivery and somebody dropped a case and sprayed on them, and maybe there's an explanation. But in all likelihood, someone who smells like they've been consuming something has been consuming something, and I would treat it that way. Send them home and maybe then consider what you're going to do about that. But that's a strong indicator of use.
Blair, we had an individual show up actually for their orientation, smelling like strongly of pot, but their claim was it was on their jacket from use before. Now, that's obviously different currently than it will be a week from now, but people tend to claim that the smell is just coming off their clothing. As opposed to alcohol, you can actually smell it on their breath, right? So we're just kind of confused, not confused, we're uncertain about how to proceed with smell. Because people will go to the place that it's on their clothes from previous usage, right? And it stays in clothes for a long time. Maybe they won't.
Yeah, I mean, I'm sure that's the response you'll get. I mean, I guess you do need to have a conversation with the person, and maybe if after a conversation, either A, you like the response, or B, you're getting the sense that the person doesn't appear to be impaired, maybe you would let it go. But if you're talking about a safety-sensitive role, I would be inclined to treat it as you can't show up at this workplace with any sign that you have been consuming marijuana, and smelling of marijuana is a problem. And, you may get pushback on that. My advice to employers typically is where you think you have a safety issue, I'd always be prepared to get smacked for being too safe. If you approach something from a safety issue and come down on an employee and they file a human rights complaint, that's not great, but it's a lot better than they have an accident and then you get charged on their occupational health and safety rules. I think the side of the angels on that one is to be on the safe side. And unless someone has a compelling explanation, I would be inclined not to accept it and to say, you need to, you can't show up here. That's not a professional way to present for work, smelling of drugs any more than it would be to pour a bottle of dark rum over your jacket and then walk in the front door. I mean, it's just not an acceptable practice in a workplace, and particularly not in a safety-sensitive workplace like yours.
Thank you. That's helpful.
Thank you for your question. Jane is just wondering, I guess talking about the designated smoking areas, I know you talked about it before, but can you basically, if there's designated smoking areas for, I guess, employees in a business, are they allowed to smoke medical or marijuana or recreational marijuana?
My gut reaction would be yes, subject to the other considerations about is it appropriate to be at work under the influence and the usual medical assessment. But if you have a designated area, and someone is smoking cannabis there for medicinal purposes, that's probably acceptable, but the same rules of being an employee apply. So whether, I think you need to have a long discussion about that would be required before you could justify taking a break from work and smoking marijuana for medical reasons.
But Blair, if your designated smoking area is deemed a public place where members of the general public can access it, they are not allowed to smoke cannabis in that area, whereas you could smoke cigarettes.
Well, that is the medicinal use is the line, right? You can,
okay.
So you can, at least right now, until it's further clarified, you can go to Bowring Park and smoke medicinal cannabis.
Right.
But you can't go to Bowring Park and smoke recreational cannabis.
Gotcha.
And I think I might have said this earlier, how a police officer would tell the difference between those two things is a very live question.
Oh, yeah, it was no guess that she was asking. Sorry.
Oh, sorry.
I think your answer clarified it, though.
Yeah, about guess, it would be clearer, I would suggest if you have a designated smoking area on your property and you have a guest who has a medicinal authorization, I think they can smoke cannabis. And then you need to think, do I want a designated smoking area on my property at all? Because that's something you're probably not going to be able to stop. And furthermore, do you want a police, right? If you own a hotel and you have a designated smoking area outside, do you want to have someone who works security going out and asking questions, you know, who's authorized and who isn't? It's a very awkward thing in the hospitality business to start drawing lines and, if you will, policing in quotation marks what's happening. So again, I think one unanticipated consequence of the legalization of cannabis is that it may further restrict where people can smoke cigarettes, because there's the concern that the two things are more or less legally equivalent, and how is that going to be handled? And I think someone said, how can you tell the difference between, I assume, between recreational and cannabis? And I don't think you can. Recreational and medicinal, I mean, unless someone shows you an authorization, you can't. So it's a real question, and I think as a business owner, that's why I would be cautious about ever allowing it at all, because it puts you in an awkward position of, and you know, how far are you going to push that with a guest in your premises?
I know there was one that was asked much earlier on that we hadn't addressed about the topic of vaporizing. Is there any difference when it comes to vaporizing marijuana as opposed to smoking it?
Well, under the Smokefree Environment Act, vaping, as they say, and smoking are essentially equivalent.
Okay.
And obviously, smoking and smoking cannabis are equivalent. So I think all three, the three are sort of tied together. So, you know, vaping tobacco, smoking a cigarette, vaping whatever it is that people vape, you know, would all fit into the same category. Someone raised a point about whether you could carry something that would confirm you were medically allowed to authorized to smoke cannabis and therefore potentially entitled to do it publicly. That's probably a good idea, and it's a good way to defend the ticket. I guess the challenge for a business owner is, are you going to go down the road of saying, show me your medical authorization? And I guess it raises the question of whether or not you're even legally entitled to demand that, which again is, I think, in the hospitality industry, the prospect of having to interrogate your customers to determine whether or not they're using something legally or illegally is a very awkward position that you probably would best avoid. Yeah, there is a question about designated smoking area also licensed for alcohol. That's I guess an interesting question. My inclination would be that it would not be acceptable to smoke cannabis there, but I think what I would recommend, if you're in a premises that's serving or selling alcohol, you obviously have an authorization from the Liquor Corp, and if you have any kind of concern about any overlap in your licensing and the implications, the one nice thing about our regulatory regime is the Liquor Corporation is responsible for cannabis too. So I think where there's any kind of overlap and any concern about consumption and how that might interfere with your, first of all, your legal obligations, and second of all, your licensing obligations, I'd be inclined to seek clarity there. I don't know for sure, but my inclination would be that it would not be permitted in a bar. But I guess if you have a designated smoking area, there is a risk. My concern would be, as a liquor license holder, am I jeopardizing my liquor license by allowing this to happen? And I definitely want clarification from the NLC before I even considered allowing that on my property.
So our final question there from Roxanne Blair is, can you ask an employee not to bring recreational cannabis to the workplace?
I think so. Some people think I'm being too hawkish on that. At work, we argue about this stuff all the time amongst different lawyers. But, I mean, my assessment is that there is no legitimate reason to bring a recreational substance that you use for intoxication purposes to work. Maybe it's not illegal, but it's not illegal for me to have a sealed flask of vodka in my pocket either, but I don't think it's appropriate to bring it around me in the workplace. So I would feel comfortable banning it from my workplace, and then you eliminate some of these questions about, well, I was just storing it. I wasn't selling it or sharing it or smoking it. It's something you're not allowed to have, and we all understand that. It may come to be that somebody pushes back on that, and the law sort of says that's too aggressive, but that'd be my starting place. Recreational drugs have no place in a workplace of any kind, and I'd say you're not allowed to have it here.
And Janet's comment there, I would reiterate, Janet, any policies you have in place in your vacation home around what is allowed to be consumed and not consumed should always be posted for your visitors to understand what your policies are as a business. So I'm just going to clue up now and for the day, and it's great questions, and hopefully we got to everything. We'll scan the questions and make sure we covered everything off, and if not, we'll get you the answers that you've put forward. Thank you, Blair, for your great presentation today. A lot of valuable information covered. Each of the participants on the call will be receiving a follow-up email with some more information on resources that such discussed today, as well as a link to an evaluation and the recording. We also will be having a series of knowledge exchange events around the province in the next few months. They'll provide opportunities for learning around pricing your tourism product and experiences and regional panel discussions. We'll be in Fort Tow, Labrador on October 22nd and 23rd, in Clarenville on October the 30th, St. John's November the 1st, Grand Falls, Windsor November the 20th, and in Deer Lake in November the 22nd. Please check your emails and on social media for the links to registration on our website. These events are only $35 per person, a special price to reflect our 35th anniversary. Also, keep watch to your emails and social media. We'll have some great announcements coming soon on some new training opportunities and programs that we'll be bringing to the industry. Thanks, everyone, for joining us today, and we look forward to working together with you in the future.